representing some new collection agency. I forget the details, but he purports to be representing one person, which is the collection agency, and there's apparently a judgment in the name of some other party, the original mortgage holder. So she sends me this file. Actually, before this Indiana lawyer got involved, she sends me all this junk. So I write to this collection agency in Texas, and I say, "What's going on here? We dispute this. Please tell me what's going on." Blah blah blah. A few weeks later, this Indiana lawyer gets involved in it, and he files something in court. Well, he was not real party. He was not representing real party in interest. So what I decided to do is just, and I kind of maybe I should turn off the tape. Maybe it's kind of pushing the envelope a little bit. But I think I was in pretty good, solid ground. First of all, by communicating with that collection agency in Texas, that's perfectly fine because I can visit in Texas federal court. And if we have an action of the Fair Debt Collection Practices Act, we'll file a lawsuit in Texas if we have. And probably in Indiana too, if I wanted to. Well, but then I had this letter from this guy and he's reporting to make an appearance in this case just because it's not the real party in interest. So I sent a letter to the court in Indiana where I'm not admitted. And I said, I am not admitted in Indiana, but I want to call this back to your attention that this attorney is acting, and I look at these rules, and it says somewhere in here it says if I see somebody abusing the legal process, I have a duty to bring that to the court's attention, and I have that duty even though it's in Indiana. So the guy wrote back to me and said, "You're practicing law without a license," and so I wrote back to him and said, "Well, that sounds like an interest case. Here's where you file the complaint, and I'll take it to the Indiana Supreme Court." And I heard he was going to drop the case. So, but yeah, I mean, that situation comes up all the time.
It's on a regular basis. I mean, I know that a friend of mine went through 3 consultations for a state plan, come to an agreement. He writes up totally after their meeting and then solicits a bill for $1,000 for doing it. So written the agreement. She went in there specifically just because it was a consultation to try to get you in the door. Next thing she knows, she has a $1,000 bill from this guy. So she called me up because she's a friend of my sister, and I looked for the Florida ethics, about writing very similar to what's going on here. So I write it, but I don't put my name on it. I just go ahead and cite the professional responsibility. I'm not acting in any court, not doing any of that, and never bothers her and drops the bill. Is that elation?
I don't think so, but because my case is more egregious than
she signed it. The letter was from her.
Yeah.
She just needed some direction.
Yeah.
Oh, wow.
Huh?
I think the letter's from her. It's over her signature.
It's her signature. I just helped her. I didn't know whether that's unauthorized.
Now that's the Nebraska rule about.
Facebook friend or not?
No, this is my one and only friend.
Now that Nebraska rule about drafting things for other people's signatures, I think that just applies to court pleadings. I think of that too.
Okay.
But these are not easy. You have to watch out for that. So it's okay by federal law. It's okay. Now, one situation probably applies to some in this room is let's say, for example, I decide to get a job with Wells Fargo, and they're a nationwide bank. They have offices everywhere, and they decide to transfer me to the Des Moines office. Well, under the Iowa rules, I can do pretty much anything for them in Iowa that an Iowa lawyer can do, because there's a special rules for that situation. That's also the law in Nebraska, but, and once again, my blue ink got printed out here, so I said, the Nebraska court rule, and then you can't read that. But if that rule, make sure that you look at the online version of that. Because Nebraska just adopted this year, you are out-of-state attorney working as counsel, I think is the word they use, for a company in Nebraska. Just like in Iowa, that's okay, you can do that. But you have to get this, you have to register with the Nebraska Supreme Court. And you pay $100. So maybe it has something to do with revenue. I don't know. But yeah, but if you're in a situation, if you're a non-Nebraska attorney working for a Nebraska corporation as kind of an in-house counsel, make sure you comply with that. It's fairly new. I don't know if it's already in effect or if it's about to take effect. So watch out for that if you're in that situation. 5.6, we're in the home stretch here. 5.6, restrictions on right to practice. You can basically never agree that I will never practice law in this state. And if you settle a civil case, you have to make the settlement read, an I, the attorney, must never to sue you again. So, if you're a good attorney, you're representing somebody in your case for, $1 million, and the opposing party, they offer you $2 million to your client. Good for your client. You have to agree to represent the plaintiff against again. You're not allowed to agree to that. Rule 5.7. Not every state has adopted this, but both Iowa and Nebraska have. I'll talk about law-related services. The 20, 30 years ago, a lot of things might have been considered the unauthorized practice of law. Like maybe preparing documents for people to sign and things like that. Sometimes there's kind of these freelance paralegals out there drafting documents for people. They don't purport to give legal advice. You can do that. That's generally okay. But what if you as a lawyer then? And the best example I can think of, you decide to get a part-time job with H&R Block. In fact, when I worked for a publisher, one of my bosses did that. He worked for H&R Block, even though he was a licensed attorney. He worked for them part-time. If you work for H&R Block preparing tax returns, normally you don't have duty of confidentiality. You don't have any duty. You can't get disbarred. Tax preparers get disbarred because they're not barred in the first. But what if you as an attorney in that? Well, normally attorneys, you don't necessarily do tax returns, but sometimes you do. In a state case maybe or something. So that might be a law-related service. So in there, if you do something bad when you're drafting a tax form, maybe you can get disbarred. But only if these two conditions. It's not distinct from your provision legal services. So if you have a part-time job at H&R Block, it takes you for law office in the day, and they're probably distinct. If you're doing tax forms from your law office, well, then maybe that's the practice of law, and you have to make sure that you comply with all the rules. Or if the person thinks that it's an attorney-client relationship. So Rule 6.1, pro bono. You're supposed to do pro bono. And what your requirement is, you should aspire to do at least 50 hours per year. So presumably you have this obligation. If you wake on January 1st, say, this year I'm going to 50 hours pro bono. Then you've met obligations that you should aspire. If on January 2nd you say to yourself, no, I'm not going to do that, well, then you stop aspiring and you're guilty of violating that. But it's not just 50 hours of anything. And a lot of the activities that many of us engage in don't offer that. What that 50 hours is serving people of limited means, not saving the environment, not fighting for civil rights, not doing all kinds of other things. It's helping persons of limited means. And you're supposed to do some of these other things too. Like improve the legal system and legal head. There are even less enforceable guidelines. I don't know how it works here, but if you're, we don't, with a good public defender's office, we don't have the court appointments, but you will not seek to avoid being appointed by a court. So, if there's some defendant in there unrepresented, you're sitting in the back of the courtroom and you leave the room, you won't get appointed his attorney, well, then you're violating that. Unless there's good cause, like conflict of interest or some other rule violation, or just be a big financial or